Good afternoon, everyone, and welcome to our May 2025 Employment Law Lab webinar. Great to see so many people on the call today. For those of you who I've not met before, my name is Jamie Meehan, and I'm a Senior Associate in the Employment Law team here at Burness Paull, and I'm delighted to be joined today by my colleague Andrew Forsyth, a partner in our Dispute Resolution team. I suppose as an employment team, we work quite closely with our dispute resolution team in a number of different areas. And one area where we sometimes work together is in relation to personal injury claims, where there's a sort of kind of workplace element. And defending personal injury claims is one of the areas Andrew specialises in. So we thought it would be good to do a bit of a spotlight on that during today's Law Lab webinar, before I go on to cover the usual kind of recent case law update section. As always, we have lots of people on the call today, which is great to see, but means probably easier if you do have any questions just to pop them in the chat box as we go. And then if we've got time at the end, we'll do our best to answer any questions that we've got in there. And if we don't have time, then of course we'll follow up with people after the webinar if there was any questions we didn't get the chance to answer. Usual disclaimer from us that we can't give legal advice on the webinar today, but if you would like specific legal advice, please do get in touch with one of us or your usual Burness Paull contact, and we'll be more than happy to help. Just some other housekeeping points before we move on. Please ensure your mute button has been selected just to limit any background noise, and we will be recording today's webinar. If you've got any queries about that, please check the privacy policy on our website. But what that does mean is that we will be able to send a recording of the session to you all after today. So with introductions and housekeeping out of the way, I'll now pass over to Andrew. Thanks, Andrew.
Great, thanks Jamie, and thanks everyone for joining today. And it's really good to speak to you about where personal injury and employment law collide, and they do collide quite often. So, but by way of context, the HSE reported last year there are 1.7 million instances of reported work-related illness or injury. So that's a lot of injuries and a lot of personal injury claims, and that is just the ones that were reported. So that's the context. So does a personal injury claim affect how you deal with an employee's termination, for example? And does an employee's termination affect how we deal with a personal injury claim? And the answer to both of those questions at once is yes, no, and maybe. And we'll be looking at why in this webinar today. So I'm conscious that there are a very diverse range of businesses on the webinar today, with a huge range of employee headcounts and a lot of different sectors and risk levels. And some of those higher risk businesses will probably have really well established in-house insurance and claims functions. And for others, receiving a personal injury claim will happen once in a blue moon. But hopefully you'll all find this helpful for when it does land on your desk. And hopefully presenting the seminar won't be jinxing it for any of you. So for most businesses, it's not going to be possible to completely eliminate employee injury risk. And when the worst does happen, it often involves some combination in responding to that of human resources and in-house legal. Hopefully this talk will be helpful to all, regardless of how often they land on your desk. So the first thing I'm going to look at is what is a personal injury claim and what is an employment law claim. And that sounds easy, but it's not always quite the clear distinction. And it's probably easiest to look at the obvious ends of each spectrum first before looking at where it becomes more of a grey area. So firstly, if an employee trips and falls in the office or suffers a serious injury in a building site, for example, these are always personal injury claims. And there are separate rules around how the claims are made, and there's distinct court processes and procedures for those. And an employee has 3 years from the date of an injury to raise a court action for compensation. At the other end of the scale, if an employee claims they've suffered discrimination in terms of the Equality Act and suffers hurt feelings as a result, and even though hurt feelings can be compensatable in personal injury claims, that would be a matter for an employment tribunal, and there are different deadlines for that. So what about the grey areas? Imagine an employee suffers stress at work, which develops into a recognised psychiatric condition. Damages could be claimed in either, or in some cases both, the personal injury courts and in the employment tribunal. And we'll go on to look specifically at psychiatric injuries later on in this webinar. So next, how an employee wins a personal injury claim. So if you're an employee injured at work, whether that injury is physical or psychiatric, you need to prove that the injury was caused by your employer or one of your colleagues being negligent. And negligence is basically a failure to take reasonable care. And under the principle of what is called vicarious liability, an employer is liable for the negligence of its employees. So if Jamie negligently knocks me over with a forklift in the office, I can sue Burness Paul for damages, for example, not just Jamie. If he did it on purpose, which he might well do, the answer might be different, but that's a whole different topic. As well as common law negligence, there are some very specific statutory obligations which impose duties without the need to prove negligence, for example, in the Protection from Harassment Act. But on the whole, with personal injury claims, we're looking at a requirement for the employee to prove negligence or something close to it in order to win their personal injury claim. And obviously, it's open to you as the employer to defend that claim on the basis that it wasn't your fault or the fault of one of your other employees. So next, if an employee wins their claim, what do they get paid? And that is very fact specific, sort of how long is a piece of string type answer. And we can see claims for the smallest of beer up to the 7-figure sums that often hit the press. And across the UK, so whether this is Scotland or England and Wales, the point is not to punish an employer. So there are no punitive damages like we see in the US, for example. And the principle is to restore an employee to the position they would have been in had the accident not occurred. So we take the case of an employee breaking their leg at work, they will always get damages for their pain and suffering. And in England, that's called general damages. And in Scotland, we like to use the word solatium, the Latin. And the courts will value that claim by looking at something called the Judicial College Guidelines, which is like a tariff-based approach. And then they'll also look at what the courts have previously awarded for similar cases. So that's the sort of starting point. And it gets more complex the higher or the more serious the claim is. So if that leg break, for example, causes an employee to be absent from work and they exhaust their sick pay, then their claim for compensation would also include their claim for lost earnings. And if that leg break is so bad that it might mean they can't return to their work, think, for example, an offshore worker who can't climb a ladder anymore, then that wage loss claim can become very high and much more complex to calculate. And there are other types of loss that could be included. That might be the cost of care or prosthetics, for example, but these are the main ones. One thing we're often asked by the Human Resources Department of our clients is whether sums paid under a company's personal accident policy to an employee are taken into account. So that is, there's a contractual benefit for the employee on a no-fault basis where they get a fixed amount following an accident. So that might be X pounds for a broken leg or Y pounds for an injury that has you absent from work for a month, for example. And these are no fault payments and they're contractual payments rather than negligence based. The general position is that these sums can't be deducted from the personal injury claim if the policy is for the employee's benefit, which it usually is. But it is good to check because there are exceptions. But what this means is often an injured employee can get a bit of a windfall by receiving both this contractual payment under the personal accident policy and also the damages under their personal injury claim. Next, we're going to look at some of the things that might clutter up your desk as a result of a personal injury claim, and that is when you're asked to disclose documents. And during the course of a personal injury claim, an employee's lawyer will typically send you letters making requests for documents. Some can be easy and some can be pretty onerous. So, for example, they might ask for personnel, wage records, occupational health records. That's all pretty normal, pretty easy to respond to. They might also ask for wage records for colleagues to prove what the injured employee might have earned had it not been for the accident. And that's generally okay too, subject to considerations about personal data and maybe redacting some personal third-party data. And these are all matters that are relevant to value the claim. Where it gets trickier is when they ask for documents that relate to the accident circumstances. So that might include risk assessments, and those are okay to give out. But when the employee's lawyer starts asking for documents like accident investigation reports or other deep dive documents, that can get tricky. And as an employer, you don't require to disclose documents that are protected by privilege. And often companies' investigations, particularly for serious accidents, contains a deep dive into systems, processes, culture, and they can be quite critical, sometimes overly so, about the company's role in an accident. And once that investigation report is out there, you can't take it back, and it's often the first item of evidence used in a personal injury claim to hang the employer. So it's always worth thinking about. It might be possible to refuse to disclose documents if it's covered by privilege. That's either legal privilege, if prepared by a lawyer or your in-house legal team, or litigation privilege, if that was prepared in contemplation of litigation. How to set up privilege is a whole other topic in itself, but one tip to take from today is that just because an employee's lawyer asks for a document, it doesn't mean you have to give it to them, and if in doubt, take advice. We've also seen, and you may have seen on this call today, increasing use of subject access requests as a tool to flush out information from employers as a sort of precursor to a personal injury claim. And this might be a claimant lawyer on a no-win, no-fee deal, testing the evidence to see if it's a case worth taking on. And it's no cost and no risk for that lawyer to make a subject access request, but it can be a huge pain for an employer to respond to because there's statutory obligations on deadlines, for example. And the kind of document the employee's lawyer might be looking for here is, again, that investigation report, anything that contains personal data about the accident. Again, a subject access request doesn't trump privilege, and if in doubt, take advice on whether you need to disclose something. And again, depending on the size of the organization, it might be that the person in the company who receives a disclosure request or the subject access request is totally removed from the personal injury claim. It is really important, as well as can be, that everyone is joined up where possible in responding to this so that nobody accidentally gives something away that they shouldn't. Next topic I'm going to cover quickly is insurance, and you'll all have employer's liability insurance cover. It's mandatory. We all have to have it. Different organizations have weird and wonderful types of cover and policy deductibles, which it means it can really vary whose money it is when paying a personal injury claim, whether it's the company's money or the insurer's. Some clients with bigger risk profiles often pay, for example, the first £250,000 of any settlement. So it's often just really the big claims that trigger the insurers. But even if the insurers are paying out, it's worth bearing in mind that the more your insurers pay for you, the more your insurance premium is going to be going forward. So even if the money isn't, if it's not your money being paid to the employee, you're not writing the check. It kind of is your money going forward by way of increased premiums, and insurers are efficient at making that money back. So I'm sure you'll all be aware that you're always best telling your insurer quickly when a personal injury claim comes in. Your policy will undoubtedly include a clause that says if you don't notify a claim properly, they don't have to give you cover. But it's not just claims like formal litigation, letters of claims. If you get that subject access request, for example, that's obviously a precursor to a claim, then you have to notify your insurers too, or give it to your insurance brokers who will do that for you. What will happen next is your insurers will typically appoint a solicitor or a loss adjuster to investigate and defend the claim on your behalf. And if that turns into a litigation, they will step into your shoes and defend the court action in your name. And a little plug here, but lots of clients ask their insurers to use Burness Paull for that. So please do keep us in mind. But of course, insurers will be on your side and they'll want to defend the claim for you. But it's a money business, and they typically approach things very economically and look at things in pounds and pence, and they will typically want to settle and buy off the risk of claims as quickly as possible. Insurers really can vary as to how receptive they are to wider issues affecting your company. For example, if you've got a really deep concern about avoiding a claims culture within the workforce or a particular team or a particular office, you have the right to speak up to your insurer. and make it known how you want a claim to be handled. But as I say, some insurers are more receptive than others to that. Otherwise, if you don't shout out, it'll typically be taken out of your hands, and the case will be defended by your insurers, and you might get the odd periodical request for evidence or access to witnesses, for example. Because insurers are involved, it creates a slightly odd dynamic. And one issue that keeps coming up is whether the company should keep paying an employee who has been injured and who has exhausted their company's sick pay. And that person may have had a personal injury claim already, or it may be in its infancy, for example. And the company will want to do the right thing by their employee. They want to see them right. And the company might also believe, maybe optimistically, that by continuing to pay the employee during their absence, that employee won't put in a personal injury claim. So what to do in that situation is really a decision for the company. An insurer is very unlikely to repay you any goodwill payments you're making to the employee. And if you stopped paying that employee, the earnings they lose because of their injury will form part of their personal injury claim, which will be a cost for insurers. So by continuing to pay the employee, you're really saving your insurer's money at your own cost. But as I say, you might want to see your employee right and not make them wait for the conclusion of an injury claim to get their money. And similar considerations apply to a decision to terminate an employment on capability grounds following an accident. You might be concerned that if you do terminate someone's employment, it might make the personal injury claim worse or somehow provoke a claim. But by keeping that person employed and paying them, you're really saving your insurer money, which you won't get back. So again, it's quite it's a judgment call, and maybe a conversation to have with your insurer too. But my general advice in these situations is to treat the employee as you would had there not been a personal injury claim. Balancing what's best for your employee and your business, and don't let the personal injury claim tail wag the dog. Okay, next I was going to have a quick look at stress at work claims, because this is one of the areas where there's quite a big overlap between employment and personal injury law, but there are distinct differences in relation to how stress at work claims are managed. And of course, the circumstances creating a stress claim might flow from a situation which would justify an employment tribunal, such as discrimination. But for stress at work to amount to a successful personal injury claim, the hurdle is pretty high. And in the first case, the employee would have to prove that the employer had actual or constructive, so that is, they should have known, knowledge that this employee was under stress and may suffer injury or was likely to suffer injury as a result. And if an employer does not have that notice, then that claim fails. So that's very different from the sort of employment tribunal claim. And secondly, the employee has to have developed a recognized psychiatric condition as a result of the stress at work. So it can't be hurt feelings. It has to be something that a independent medical expert would say is a recognized condition, and there are different scales and different criteria for that. So an adjustment disorder or PTSD, for example. But by way of comparison, if there's a personal injury claim under the Prevention from Harassment Act 97, there's not the same need to prove a recognised psychiatric condition, and the Act allows damages for anxiety, for example, as well as financial loss. So moving on to when you're settling claims and the risk of double compensation. When negotiating a settlement with an employee in respect of a termination, for example, it will have to be considered whether personal injury claims are carved out or if they're included within that settlement. And if an employee has suffered a personal injury not relating to the termination of his employment, as in it's completely different, then that will usually be carved out. So they can settle their employment claim, and then they within 3 years they have this right to pursue a personal injury claim for their broken leg or what have you. Where the accident does relate to the termination of the employment, so that might be where the employee is the employment is terminated on capability grounds, and they're no longer fit to carry on with their work as a result of the accident, then that will typically be carved out too. It would be very unusual for that to be covered with the same settlement agreement. So in both situations, an employee can crack on with their personal injury litigation despite having settled their employment claim. When it becomes more grey is that if an employee has a grievance and alludes to a personal injury claim too, the typical example again being stress or harassment claims, then the settlement agreement will require to be very carefully drafted to make sure that everyone is clear whether a personal injury claim survives that settlement agreement. And that might lead to a situation where an employee tries to negotiate a premium on their termination package to buy off those personal injury risks. And finally, on these settlement agreements, it's worth noting that it's not possible for an employer, it's not possible for an employee to waive future unknown personal injury claims. So, for example, if an employee enters into a settlement agreement and tries to waive his personal injury claims, but it turns out that he has developed noise-induced hearing loss that he didn't know about, or even worse, an asbestos-related claim, for example, despite a very broad waiver in a settlement agreement, the employee can still put in a personal injury claim for compensation. Okay, that's really a very brief canter through how employment law and personal injury law interacts and collides. I was going to leave you with some top tips which touch on what we've just been discussing there by way of summary. And firstly, that is to take a breath when responding to subject access requests and disclosure requests. As we said, if we can be, let's be joined up between the various different functions that are dealing with the personal injury claims and think whether something needs to be disclosed, which is also the point of the second bullet point there. Consider legal privilege when responding to these requests. Next, notify your insurers and brokers in good time following an incident which may give rise to a claim, or something like receiving a subject access request, which is obviously a precursor to a claim. Otherwise, you risk your insurance cover. Next, open a dialogue with your insurers or solicitors they've appointed early if you feel strongly about how a personal injury claim is handled. Don't let the personal injury claim tail wag the dog when it comes to decisions around payments beyond sick pay and terminating someone's employment. These are often difficult and sensitive issues, but don't, as I say, the personal injury claim shouldn't totally drive your decision making there. Next, if there is a contractual no-fault personal accident payment due to the employee, it should be considered whether that can be offset from their personal injury claim. Two, the answer is probably not, but I have seen some examples where it can be. If there is a stress at work claim, gather evidence as quickly as possible relating to the knowledge of the company of the employee's complaints. With employees' movement in and out of the company, for example, this evidence might be lost. So the quicker you can gather it, the better. And finally, make sure a settlement agreement with an employee correctly reflects whether a personal injury claim is to survive that settlement agreement or not. Okay, I'll pass back to Jamie now. I hope you all found that helpful, and please do feel free to drop in any questions, which I'll deal with at the end.
Thanks, Andrew. That was super helpful and always nice to have colleagues from other teams contributing to our Law Lab webinar. So thanks again for giving up your time to join us today. And as we say, if anyone does have any questions on any of that, feel free to pop them into the chat and we can come back to them at the end. 3 cases from me today, case names on the slide there. And I think the obvious place to start really is the Supreme Court decision in For Women Scotland against the Scottish Ministers. I'll take a stab in the dark and say that you've mostly probably heard of this case already in the past few weeks. In fact, it was just over a month ago on the 16th of April 2025 that the Supreme Court handed down its unanimous decision on the interpretation of man, woman and sex in the Equality Act 2010. The background to the case really was that the Scottish Government had issued guidance on a piece of legislation called the Public Boards Scotland Act 2018. This legislation sought to address underrepresentation of women on the boards of Scottish public bodies. And the legislation and the associated guidance said that the definition of a woman for achieving the purposes of that 2018 Act and for achieving the gender representation objective of 50% of women on public boards would include trans women. In other words, it wasn't only about biological sex, and it would include someone with a gender recognition certificate stating that they were a woman. For Women Scotland, a charity and feminist group took issue with this and litigation followed. By the time the case got to the Supreme Court, the question was whether the Inner House of the Court of Session was correct to find that sex under the Equality Act meant being a man or a woman, including those with a gender recognition certificate, a GRC. That meant if you had a GRC, which said you were a woman, then you were a woman for Equality Act purposes and for the purposes of this gender representation guidance from the Scottish Government. And in a nutshell, the Supreme Court disagreed with that decision of the Inner House of the Court of Session, and the Supreme Court held that the terms man, woman, and sex in the Equality Act refer to biological sex and not certified sex. And the Supreme Court essentially said that to hold otherwise would make certain aspects of the Equality Act incoherent and unworkable. And if you read the judgment, they give some examples of that. So one example was the pregnancy and maternity discrimination section of the Equality Act. So that, I suppose, in a nutshell, was what the Supreme Court decided. Important to note, I think, that the court did also stress that trans people or people with the protected characteristic of gender reassignment were still protected under the Equality Act, including that they still had the right not to be discriminated against or harassed because of or related to that protected characteristic. And what the decision means is that the Scottish Government's guidance on the 2018 Act was wrong. But of course, the real implications are much wider than that. It's a decision which some have welcomed, including because they say it brings clarity. And I think at a basic level it does. It's clear now that sex for Equality Act purposes means biological sex and not certificated sex. But I think what's less clear are some of the kind of practical consequences of the judgment and how employers are to implement it without giving rise to other risks. From the discussions we've been having with clients, it seems there's no risk-free option going forward because there will be a risk of claims from protected groups regardless of which policy route you go down. So I suppose employers clearly need to be mindful of what the decision says. It's case law authority, it's from the Supreme Court, so we need to be taking that into account. We need to be mindful of what the Supreme Court decision says. Taking into account also the EHRC guidance on it, albeit that's only interim guidance for now, and we are expecting updated guidance, which the EHRC is currently consulting on at the moment, and also other obligations which are at play here in certain situations. So we're thinking about things like health and safety regulations, building and construction regulations when thinking about single-sex facilities, for example. We'd recommend that employers should have a considered approach with preparedness in terms of employee relations in particular. And clearly, in all of this, we think that communication will be key. In terms of what we're seeing happening as a consequence of the decision, we are finding that the employers that we work with are waiting on the updated guidance from the EHRC, but are also reviewing policies and practices in the background in preparation for that. And I suppose to ensure that there's no particular compliance issues in the meantime, now that we do have the Supreme Court decision. So a bit of a watching brief on this, but certainly, we've got the Supreme Court decision, we've got updated guidance. So employers still reviewing what they're currently doing in terms of what policies say, what their practices are, just to make sure there's no compliance issues while they wait on that updated guidance. I think for employers, this remains a complex area and one where we would definitely recommend taking tailored legal advice. The next case then is the case of Campbell against Sheffield Teaching, North Hospitals, NHS Foundation Trust and Hammond. In this case, the claimant was a black man. He was employed by the trust and he worked as a Unison branch secretary. Mr. Hammond also worked for the trust and got into an argument with the claimant, during which he made certain comments to the claimant which were said to amount to racial harassment. This gave rise to a claim of harassment related to race under the Equality Act by the claimant against the trust as the employer, but also against Mr. Hammond as an individual named respondent. And I think that's certainly something that we're seeing more of. As I'm sure most of you will be aware, when employees bring Equality Act claims, they can and often do bring the claim against the employer, but they can also bring the claim against individually named respondents, whether that's the alleged harasser or perpetrator of the discrimination, the manager who swept under the carpet, the HR person who didn't deal with it properly. So we do see claims brought against individuals as well as the employer when it comes to the Equality Act, and this was one such example of that. There was two kind of aspects to the judgment, really. The first was whether the comments were made in the course of employment or not, and I'll just touch on that really briefly before I go on to the second point, because basically what the tribunal and the EAT on appeal found here was that, yes, the comments had been made, but they decided that they had not been made in the course of employment. And so the trust, i.e. the employer, wasn't liable for that. They also then went on to find that the employer, the trust, had taken all reasonable steps to prevent Mr. Hammond from racially harassing the claimant. So in other words, this is I suppose, a somewhat rare example of an employer successfully making out the all reasonable steps defence. So as you'll no doubt be aware, the Equality Act provides a possible defence to Equality Act claims where employers can say, well, yes, the discrimination or harassment took place, but we took all reasonable steps to prevent it, and so we shouldn't be liable for it. So that defence has been in the Equality Act for a number of years, but a notoriously difficult defence to prove, and actually quite a difficult one to find case law authority for where it's been successfully made out, which is, I suppose, part of the reason why we wanted to bring it to your attention in today's webinar. And it's a difficult defence to make out because it's an all reasonable steps defence, not a some reasonable steps defence. So you really have to do quite a bit to get over that hurdle and to successfully defend a claim on that basis. We've seen cases like Allais against Galen, where it was said that the employer's training was stale and no longer effective to prevent harassment. The case of Taylor against Jaguar Land Rover, where it was said that the respondent had some policies but did little or nothing to publicise or implement them. And in both of those cases, the defence failed. The EAT's decision in Campbell is the opposite of those decisions, really. This is an example of where the defence was successful. In terms of why they found the comments hadn't been made in the course of employment, that was essentially because despite the comments being made on the trust's premises during working hours, it was during a conversation between a union official and a union member about union membership. Whether Mr. Hammond was a trade union member was his personal choice. He didn't have to be employed by the trust. And the conversation that he was having with the claimant, during which he made these comments, was about that union membership, or specifically a personal dispute he had with the union about deduction of subscriptions. So it was for those reasons the ET and the EAT said, well, that wasn't during the course of employment. But the tribunal, upheld on appeal, went on to find, well, even if it was, those comments were made in the course of employment, we would have nevertheless found that the employer had taken all reasonable steps to prevent the comments from being made, to prevent the racial harassment. And I think it's helpful for HR professionals and employers just to focus on that part of the case. I think it provides some useful guidance for employers who are thinking about how to take reasonable steps to prevent discrimination and harassment. And I suppose not least because there's now this positive duty on all employers to prevent sexual harassment of employees in the course of their employment. And that duty will be increased shortly through changes we're expecting from a duty to take reasonable steps to all reasonable steps. I think this case is quite helpful just to understand what all reasonable steps might look like. So The steps which had been taken in this case, the Campbell case, were as follows. So there had been an induction session attended by Mr. Hammond, at which the issue of acceptable behaviour at work and the employer's core values of affording dignity, trust and respect to everyone, which they refer to as their proud values, were emphasised. So when Mr. Hammond starts employment, there's an induction session on this and on the values of the trust. There was then an annual performance assessment of Mr. Hammond, which covered the issue of whether he was acting in accordance with the proud values. There was the display of the values on posters in areas where Mr. Hammond worked. And then crucially in this case as well, there was mandatory training on equality and diversity issues every 3 years, but most recently just a week or so before the particular incident had taken place. And the training was conducted in small groups, and it involved the employer going through a PowerPoint presentation. And that presentation referred to the promotion of a positive attitude towards equality and diversity by showing respect for others, valuing people's differences and treating people with dignity. So those were essentially the 4 main steps which the employer said they had taken, or it had taken, to prevent this from happening, to prevent discrimination and harassment from happening to its employees. And it was held by the tribunal and upheld on appeal that these steps were sufficient to make out the all reasonable steps defence. A slightly techie point, but just to qualify that, is that it was noted by the Employment Appeal Tribunal that no further steps that could have been taken were suggested either in the evidence or referred to in the submissions to the tribunal during the hearing. So if there had been, then it wouldn't have necessarily changed the outcome, but I suppose the point is that it could have. But in any event, this decision, I would say, and those kind of those four steps provide some helpful guidance for employers, certainly at the very least a kind of minimum or a starting point to be thinking about in this area. I've been doing lots of work with clients in the context of the new duty to prevent sexual harassment recently, and that often leads on to discussions about preventing discrimination and harassment more generally, and kind of rolling out training to staff on that, updating policies, all of those sorts of things. And I think this decision is quite helpful with that in mind as well. And please do just reach out if it would be helpful to have a discussion on any of that after the webinar today. And then the next and final case is one for the TUPE lovers. I know there are some of you out there, and that's the case of ABC against Huntercombe. And this was a case where ABC had raised an action in the High Court seeking damages for injuries suffered while she was an inpatient at a hospital owned by Huntercombe. And she argued that Huntercombe should be vicariously liable for the alleged actions of the employees who caused the injuries. So a bit of an overlap of with what we were talking about earlier. But what does this have to do with TUPE? Well, the employees who she said were responsible subsequently had their employment transferred to another employer, AYP Limited. So Huntercombe was the transferor and AYP Limited was the transferee. And the High Court had to determine whether any vicarious liability that Huntercombe owed to the individual, to ABC, for the alleged wrongs or negligence of the employees that it employed immediately prior to the transfer, whether that transferred to AYP Limited under TUPE. As you may be aware, under the TUPE regulations, where a relevant transfer occurs, all of the transferor's rights, powers, duties and liabilities under or in connection with the transferring employee's contracts of employment pass to the transferee. And we sometimes say the transferee steps into the shoes of the transferor. Well, in this case, the High Court has decided that any vicarious liability of Huntercombe did not transfer to AYP by virtue of TUPE. And in reaching this decision, the High Court placed importance on the fact that vicarious liability is a sort of secondary liability rather than a direct liability. It was noted that the relevant case law about what transfers under TUPE all dealt with liabilities owed by the transferor employers to their employees directly. What had happened here was different. It was about vicarious liability rather than direct liability. So Perhaps some good news for employers here, or transferee employers anyway. But the decision did get me thinking about, again, the upcoming changes to third-party harassment and the extent to which those might transfer. So, as you may know, we will see the reintroduction of liability on employers for third-party harassment where it takes place in the course of employment. And the duty to prevent harassment will be extended to prevent third-party harassment, that's third-party sexual harassment and other types of harassment. And I think that new duty, that new third-party or new duties to take reasonable steps to prevent third-party harassment, feels to me more like it will be akin to a direct liability and less like a secondary liability. So I suppose not only something which employers will have to be planning for generally with the changes coming into effect, but potentially also something to be thinking about when carrying out due diligence as part of a TUPE transfer, whether that's a business or an asset transfer or a service provision change TUPE transfer. So those were the three cases that we wanted to touch on today. Just in terms of some other really quick updates that we wanted to briefly mention before we finish up. The first is in relation to the Vento bans for injury to feelings compensation in discrimination and harassment claims in particular. So for claims presented on or after the 6th of April 2025, the Vento bans, as they're known, have gone up as follows. So the lower band will now be £1,200 to £12,100 for less serious cases. There is a middle band of 12,100 to 36,400. So that's for cases which don't fall into the less serious category, but don't merit an award in the upper band. And then the upper band is now 36,400 to 60,700 for the most serious cases. And of course, with the most exceptional cases above that, you can get injury to feelings in excess of 60,700, but that's of course exceptional, and most cases will fall within the lower, middle, or upper Vento band. And just when we had almost made it to the end of an employment law update webinar without any kind of substantive standalone section on the Employment Rights Bill, just a really quick word to say there are no substantive updates as such to the Employment Rights Bill. It's still making its way through Parliament. It's currently at the House of Lords committee stage. The next sitting of that, though, will be at the start of June, so we might see an update shortly thereafter. And of course, as you'll know, the Employment Rights Bill will bring about some of the most substantial changes to employment law in a long time. So please do reach out if it's something that we can help you in terms of understanding or kind of just getting ready generally for what those changes might look like for your organisation in practice. So that brings us on to, we've got some time left for questions. I don't see any in the chat function, which I'm sure is a reflection on how comprehensive our content has been, and not anything else. But we do still have a couple of minutes. If anyone does have any questions, feel free to pop them in the chat box now. Just a reminder, obviously, that we can't give legal advice in the webinars, but we can do our best to give some kind of general guidance and answer to any questions which you want to pop in the chat box. Similarly, though, if you'd rather speak to us offline, then please do feel free to reach out to one of us directly or your usual Burness Paull contact if you do have any questions. So don't see any questions in the chat function. So I suppose we might just finish up slightly ahead of time. We can all have some time back in our day, which is usually no bad thing. So I suppose all that remains for me to say then is to thank everyone for joining today's webinar. As always, lots going on in the world of employment law, and we hope you've found that useful. Thanks again to Andrew for being our guest speaker today, and our written bulletin will follow in the usual way. And if we can be of any assistance or you've got any questions after today, please do just get in touch and we'd be more than happy to have a chat. So thanks everyone and enjoy the rest of your day.